And let's give it another minute or so before we kick off the session. And thank you to all of you who are connecting right now. There was a record registration really for this event, so we're happy to know that it was of interest to many of you, and thanks for taking the time today to be with us. And of course, thank you to all the panelists for their time. Okay, it's 12:30. Why don't we go ahead and get started? I know folks will be connecting, but there's so much to talk about, and I don't want to waste another second of time before we get started. So good afternoon, everybody, and welcome to Acts of War Accountability for Cyber Attacks in Ukraine, webinar organized jointly by the Washington Foreign Law Society and the Simpson Center. I'm Michael Todori, president of the Washington Foreign Law Society, which was founded in 1952 to promote knowledge and understanding of international and comparative legal issues and foreign law. Our co-host today is the Simpson Center. Simpson is a leading think tank based in Washington, D.C., with offices in Brussels and non-resident fellows really around the globe. Today's event is part of a series that the Washington Foreign Law Society and Simpson have jointly produced to examine and discuss legal accountabilities in the cyberspace. And if you haven't followed our prior events, I do encourage you to do so. I'll put the link in the chat so you can catch up on all the events, interesting events that we've had over the past months and year. Today's session will be moderated by Bruce Mcconnell. Bruce is a board member and distinguished fellow at the Simpson Center. So welcome, Bruce, and thank you. A couple of very quick housekeeping notes before I let Bruce introduce the panelists. You can use the Q&A feature at the bottom of your screen to send us questions. Now, we already have had a huge influx of questions, so we don't know how many questions we'll be able to address, but we'll strive to get to as many as possible. The session is being recorded. You can catch the recording, rewatch it at the end of the session when we upload it on our website. And finally, don't forget to follow us on Twitter and LinkedIn. Our handle on Twitter is @WFLS1952. One final note, do please consider becoming a member of the Society. There's a discounted rate for students and government nonprofit employees. There's a lot of interesting stuff that we do. So I do encourage you to take a look at the website, and I'll put also in the chat a link for the membership. Bruce, the floor is now yours to introduce the panelists.
Thank you, Michael, and good day, everyone. Thank you all for joining us. We're showing about 73 participants right now and more people coming in, so there's clearly a lot of interest. My name is Bruce Mcconnell, and I am a distinguished fellow and board member at the Simpson Center and former Deputy Undersecretary for Cybersecurity at DHS. As you know, this webinar was originally scheduled to occur 2 weeks ago. What a difference a few days can make, though. We have gone from activity below the threshold of armed conflict to active warfare. Reflecting these changes, we've reorganized our panel. So here's our plan. Juan Guerrero, a leading global cyber threat intelligence expert, will kick off with a summary of what's happening on the cyber side of the conflict, covering state and non-state actions on both sides. Juan will be followed by our two legal experts, Professor Lori Blank, Director of the International Humanitarian Law Clinic at Emory University, will discuss the law of armed conflict and its applicability in the current situation. Lori will be followed by Lise Vihul, who is joining us from her home base in Tallinn and CEO of Cyber Law International, and she will cover peacetime cyber law and how it applies. I will then moderate a discussion on some of the issues, including questions we've received from you in advance and what might come in on the Q&A. All righty, Juan, take it away.
Thank you, Bruce. So good afternoon, everybody. It's a pleasure to be here. My name is Juan Andrés Guerrero Saade. Jags or Juan is easier for everybody. We can just keep it that way. As Bruce mentioned, I'm cyber threat research over at Sentinel Labs. I'm also an adjunct professor now at the Alperovich Institute at SAIS. Hopefully I can kind of bridge the gap a little bit between your world of international law and legal expertise, which I don't avail myself, and what's happening on the technical front, on the cyber front. So for folks who haven't been following along, 2 weeks has made a world of difference, as Bruce said, and to some extent, while I despite the situation that's going on in Ukraine, I'm glad that we ended up waiting and having this event when we did, and had a little more context for how things actually went down, as opposed to how we expected things may go. So For folks that haven't followed along the situation in Ukraine, actually, there's a long history of cyber attacks. I think there was this sort of notion, maybe a little too Western centric, of thinking that Ukraine was a sort of test bed for cyber attacks from Russia. I think it's a valid target in and of itself, and one that has endured quite a few attacks, not just in the past 2 weeks. So for folks who were not aware, 2015 and 2016 saw different attacks on the Ukrainian power grid, whether it was Black Energy 2 or Indestroyer, as different researchers call it. It's perpetrated by a group we know as Sandworm, and there's a fantastic book by Andy Greenberg from Wired with that name that, you know, if you're interested in the situation, it's definitely some required background reading and some very accessible reading. But in any case, we've seen sort of Russian attacks on the power grid, on industrial control systems there. Of course, there was a 2017 NotPetya attack, which was a bit of self-spreading wiper malware aimed directly at Ukraine, though it did have some spillover, and that's a relevant topic to contrast with what we're seeing now. And then more importantly, more recently, we've seen the deployment of other types of wiper malware, which by that I mean malware that's just meant to cripple a system, right? It's meant to make your computer unbootable. It's meant to make you lose access to all your files, like a ransomware for which there is no key. And in some cases, they have disguised it as ransomware. It's actually really interesting to think about these attacks for folks who might not understand how cyber attacks actually occur. It's quite different from any other kind of attack in that the changes are gradual. Most cyber attacks are done for espionage purposes, at least on the nation state level, and they tend to be covert by default. The nature of a cyber attack is such that unless you go out of your way, most victims and targets are not going to notice that there's something amiss in their computer. The problem then becomes that you have this gradual change from having foothold and access in a network to then having effects, destructive effects, like sabotage malware, like wiper malware. And I think that's some of the gray area that we tend to have difficulties with when it comes to cyber attacks. It's not the same as saying, well, if I sell you an AK-47, then there's only so many things you're going to do with this particular type of weapon. I mean, maybe that's more of a loaded conversation in the States than I intended. But I mean, you know, a missile has a specific kind of use. When it comes to cyber attacks, a backdoor can be the beginnings of an espionage attack. It can be an attempt to have a beachhead on the network and maybe never use it. It can be reconnaissance, or it can be the beginnings of something more destructive. So cutting to the chase, what we're seeing in Ukraine, particularly in the past few months, is an ever increasing tempo of denial of service attacks. Distributed denial of service is sort of like the entry threshold to cyber attacks. It is sort of the low-hanging fruit, but it's a kind of persistent nuisance that tends to knock websites down. In some cases, it can have greater effects. Like if you target, let's say, a network that powers the ATMs and it's unavailable, you can have a greater effect with a denial of service attack than you might otherwise intend. There's a lot of website defacements, which, again, we tend to think of it as sort of low-level stuff, but it's meant to show kind of a sort of greater foothold that these attackers can have. And then the part where it gets really interesting for us as researchers is actually sort of the espionage and subsequent use of wiper malware to disable systems. In particular, we've been focusing on something we call hermetic wiper. Got to name this wiper on the basis of a stolen digital certificate that they were using with a similar name. The thing about hermetic wiper is, to us, it sort of catalyzed the new operational tempo that accompanied the invasion. We became aware as an industry of hermetic wiper at, I want to say, 3 o'clock Eastern time. By, I think, 8 o'clock, 9 o'clock, we were seeing the actual invasion. And sort of was like this sort of peak of increasing attacks that prefaced actually seeing the invasion take place. And I think that that might be sort of the point at which the cyber component of this hybrid warfare invasion really peaked. Like, that was when cyber was most relevant, before you actually see, you know, real bombs and planes and bullets coming into play. And then despite our best expectations, despite sort of the fictional account of what cyber warfare should have looked like, what the New York Times might have thought cyber warfare would look like, the reality of it is that as the power goes down, as people step away from their computers, as networks become less reliable, obviously cyber attacks also become less important, less prevalent, less effective. So I hope that that's kind of a realistic portrayal of what we've seen on the cyber side in Ukraine so far. I think there's all kinds of conclusions to draw from that. I think there's also a lot to understand about the threat actors involved, particularly from an attribution question. But that's where we start to get into some more complex topics, whether it is, in fact, Russia, not to say that there's that much of a doubt, but rather there's also components that look like it might be Belarus, right? There's not, attribution is never quite as simple as we'd like it to be in cyberspace. There's also, now potentially non-nation state actors involved. There's, patriotic hackers, quote unquote, hacktivists, quote unquote, and the doubt that comes with not knowing whether those are in fact non-state actors or state actors under the cover of hacktivism, which we've seen plenty of. So it is a very complicated space. And I don't envy the task of trying to apply norms and law to that space, but I hope that I can at least serve as a backdrop of technical understanding to how we try to approach it.
Thanks, Juan. That's a great introduction and portraying the complexity, and that's why we have our experts here who are going to pick it apart and make it crystal clear for all of us in this muddy domain. And Lori, you're up next.
Okay, wonderful. Thanks so much for having me, and good afternoon to everybody. So I could say that I can just put a crystal clear layer all over all of this, but of course, law can only do so much to clarify a situation. That said, I think one of the challenges in thinking about international law in this space is not what is the law, because we have extensive law that's relevant. It's, of course, how do you understand how it works in the context of actions that are difficult sometimes either to identify exactly what's happening or who's doing what. So let me start with the blanket statement that international law applies to activities in cyberspace, to the cyber domain, however you want to phrase that. All the things we're talking about today, there's no law-free zone. There will be aspects that don't really implicate or trigger international law. And I know that Lisa is going to talk about issues below the threshold of armed conflict. So I'm sure she'll touch on some of those, right? So almost like anything else, we have to think about the web of domestic and international law and so on. So in the context of Ukraine and thinking about cyber activities in the space of a conflict or a potential conflict, we're thinking about the same two bodies of international law that we would think about if these were kinetic activities. And the first one is the jus ad bellum, which is the law governing the resort to force. Now, in this context, there's been an armed conflict going on between Russia and Ukraine since 2014 as a matter of law, right? Not as a matter of at any given day, are they actually exchanging fire? But as a matter of the application of international law, I just want to note as a backdrop that since Russia occupied Crimea, there has been a state of international armed conflict between the two countries, and that has not abated. That law has not changed. That is based on the facts on the ground. So some of the things I talk about will not necessarily be relevant to Ukraine because we're already in the midst of armed conflict. But nonetheless, the law governing the resort to force in the international system, which is the UN Charter, applies to cyber. And in general, the starting point is states are prohibited from using force against or in the territory of other states. So a couple of things for particularly relevant to cyber. The first thing is you'll notice that I said states are prohibited from using force. And what Juan was just talking about was the multitude of actors, some of which are state actors, some of which are non-state actors. The use ad bellum does not prohibit a non-state actor from using force. Domestic law certainly does, right? It's not that they're just immune from any regulation by the law. It's just that the prohibition of the use of force applies to states, because the idea is to prevent states from escalating their disputes into armed conflict. So that's one thing. The next thing is you have to understand what is a use of force in order to figure out whether a state is violating that prohibition. And in general, under international law, a use of force is an action that causes death, destruction, or injury. Any cyber action that causes effects to that at that level will be a use of force. And it is also generally, there's a general consensus that the loss of functionality, certainly the permanent loss of functionality or an extensive loss of functionality, would also rise to that level. Above a use of force is the threshold of armed attack, which is what triggers the right of self-defense. And it is possible for a cyber action to reach that level, but it would need to reach the level of gravity that we think of for a kinetic action that constitutes an armed attack. So it would be, again, causing death, destruction, or injury, but at a scale and effects that is considered to rise to the level of an armed attack. If that definition doesn't feel terribly satisfying, that's because that's the definition under international law. An armed attack is the gravest form of a use of force, but it's no mathematical equation, right? You have use of force, and really bad ones are armed attacks. So in the cyberspace, most of the acts that occur, most of the actions that Juan was describing, if we took them into a non-conflict scenario, most of those would stay below that threshold of the use of force. So I'm going to segue out of this area, and I'll leave that for Lise to pick up in terms of what are the consequences of all of this malicious and nefarious activity taking place just below this threshold where they bubble over into the use of force space. The second area, which of course is highly relevant to Ukraine, is the law of armed conflict. Also the law of war, international humanitarian law, three terms that all mean the same thing. And there's a couple of questions. One is, could cyber acts trigger an armed conflict? They can. Again, it would have to be cyber actions that meet the threshold for armed conflict. So if it's a state on state, it's any dispute between two states leading to the engagement of their armed forces. One state engages in a cyber operation at the level of an attack, right? Some type of act of violence against the other state's armed forces, you would have international armed conflict. That said, you don't have to have this figured out by cyber alone, right? In the case of Ukraine and Russia, there's already an armed conflict going on. The cyber activities become part of that armed conflict. So the next question then is, how do we think about international law regulating that? And I just want to point to a couple of things before I turn it over to Lise. So the first thing is that all of the rules for things like distinction and proportionality and precautions, the rules in the law of war that are designed to protect civilians and the civilian infrastructure from the hazards of war, those are triggered when the action of a party constitutes an attack under the law of war, right? Which is basically an act of violence in offense or defense against the adversary or civilians. So in general, a cyber operation that results in physical damage, injury, or death, or a permanent or significant loss of functionality will be an attack. What does that mean? It means that the party that launches that attack, whether state, armed group, other non-state actor, lone hacktivist, anybody in the course of that conflict, they must distinguish between civilians and fighters, make sure they're not attacking a civilian target, make sure they're minimizing the harm to civilians, and so on. If it is below the level of an attack, there is still a basic obligation for all parties to a conflict to take constant care to protect civilians from the dangers of military operations. So that would be relevant. That's a more general obligation. And the last point that I want to highlight is going back to some of what Juan was talking about, which is thinking about that from the status and rights and protections of the actor in the cyberspace, the non-state actor, the state actor, whoever is engaging in these cyber activities, thinking about what either their protections are or what actions can be taken against them. And in general, in armed conflict, we think about either combatants or fighters who are targets at all times, and we think about civilians who are not targets unless they're directly participating in hostilities. So in thinking about what is the consequence of somebody engaging in cyber activities in the course of a conflict, we need to either figure out whether they are a member of one of the armed forces participating in the conflict, or if not, is the action that they're taking, does it amount to direct participation in hostilities? And if it does, they can be targeted at that time. They also could be detained. I think many of the folks engaging in cyber activities are not necessarily even located in Ukraine, so that adds additional complications to these things. But these are some sort of entry points into the relevant framework. And the last thing I would say is that even though we talk about cyber war, cyber warfare, cyber attacks, each of those words either has a particular legal meaning or doesn't play into the international law analysis. So the word attack has a very particular legal meaning. The word war, we've thrown that out in international law, basically. It's a political term only. And so we can say cyber war, cyber warfare, but doesn't actually tell us anything about the legal regime, because war was too easy a word for states to manipulate. And so as a matter of law, we don't use that as a triggering word anymore. Things like active war and so on. We see active war in domestic statutes that trigger certain federal or other authorities, but as a matter of international law, we don't actually use that term anymore. So I will turn it over there.
Please.
All right, Bruce, thank you so much. Good evening to everybody on the eastern side of the Atlantic. Good morning, good afternoon to those of you on the other side of the pond. And I guess to everybody else, hello to all the insomniacs out there in cyberspace. What I was thinking about saying as my introductory remarks has to do with actually zooming the conversation out a little bit, and rather than immediately dive into doing a legal analysis of the various cyber operations that we've seen in the Ukraine-Russia war, just maybe even say some things that on the philosophical side of things as they relate to international law. And I suspect that many of you at this point may be questioning the value or the utility of international law, especially in the face of the egregious violations of international law that we are seeing, that we continue to see by Russia in the war. And I suspect that many of you may be thinking, if international law is incapable of preventing this type of situation, this kind of war, isn't it time to stop pretending that international law matters? And isn't it time to stop pretending that international law works? Now, when this kind of sentiment is expressed, and again, I mean, you haven't expressed this, but I would think that these are the thoughts, at least in some of your minds, then often what happens is that people cite a very famous, influential, maybe even the most influential American legal scholar of the previous century, Louis Henkin. And what Henkin famously said is that almost all nations observe almost all principles of international law and almost all of their obligations almost all of the time. And I find this recognition really helpful in appreciating the bigger picture, which is that, of course, violations of international law occur in the international arena, just as they do in every domestic legal setting in the world. The reality is that most states take the obligations that international law places on them seriously, and most states, most of the time, accept that international law places certain limitations on their sovereign free will. Of course, this is not to say that international law is perfect, that international law has all the answers. That is certainly not the case. But the truth is that if we did not have international legal rules, including the ones that Laurie just mentioned, the prohibition on the use of force, the rules governing the conduct of warfare, if we did not have those rules, then we'd be deprived of an important basis for, in this case, condemning Russia's actions against and in Ukraine. And so I would say that in these sorts of crisis situations, it is especially important to uphold international law, to condemn activities on the basis of international law, and to engage in various kinds of activities to enforce international law. And fortunately, this is also something that we are seeing happen already. Take, for example, the General Assembly resolution, aggression against Ukraine. As an example, if you read that resolution, the first 3 paragraphs of the preamble invoke international law. The preamble first reaffirms the paramount importance of the UN Charter. Then the second paragraph recalls the prohibition on the use of force. And then the preamble goes on to remind countries of their obligations under the Charter to comply with those obligations in good faith. And likewise, the operative part of the resolution invokes various relevant rules of international law. And so as we're focusing our conversation today on international law, just bear in mind that we need to differentiate between 2 separate issues, which are clearly also evident in the Ukraine situation. The first is, what are the legal rules, including the legal rules for the various cyber operations that we are witnessing in interstate affairs? So what are the legal rules? And a separate issue is the enforcement of those rules, how to ensure that those rules are abided by and how to deal with violations of those rules. So I'll stop here, and as we go on, I'm happy to also look at the various cyber operations individually on a case-by-case basis and share my thoughts as to whether they comply with international law or not.
Great, thanks so much, Lise. I think we will be getting back to that, and in particular, some of the non-state actors and how those might be covered, not only by domestic laws, but by peacetime cyber law. I would note that we've received over 24 questions from you, the participants, in advance of this webinar. There's over 125 participants right now. These questions covered a wide range of topics, and we're going to try to stay focused here on the legal aspects of the current conflict and related technical challenges, and forego many of the tempting and interesting questions like preventative warfare, NATO Articles 3 and 5, political matters, etc. One thing we're not going to cover today is cyber insurance. Maybe we can do a separate panel on that. But as you know, there has been some interesting judicial activity recently around the applicability of the war exclusion. And I believe the Geneva Association has really recently put out some guidance on that. I think Deborah Decker from Stimson will be sharing that in the chat. All right, let's start with some practical questions here specifically. maybe you can start with this, Lori. How may, and Juan, you may have perspectives as well, I think, how may law be informing decision-making in US and NATO on the government side, and then also on the private sector side in terms of their responses? What kind of conversations are going on in where counsel is advising the cyber teams in governments and in the private sector? You want to start, Lori?
Sure. So, I mean, I think my overall answer is I sure hope law is informing decision making. It should be part of every decision making process. So that's the overall point. I have no doubt in the NATO capitals that there are lawyers deeply embedded in every conversation, for partly because that's the nature of those interactions to begin with, but also because if you watching the overall situation, right, not just thinking about cyber, but what we're watching here is an effort by the NATO in particular and other partners and allies to bring almost every tool to bear to try to bring an end to Russia's, I'm going to call it aggression with a lowercase a. I think is a pretty solid argument that it is aggression with a capital A, meaning as a matter of international law, but certainly descriptively it's aggression. We're seeing almost every single tool brought to bear, and that means that's all enforcement of international law. Every sanction that's put on, every single step that's taken, that is the enforcement of international law. We tend, I think, in the popular discourse to think that when one state engages in military adventurism, for lack of a better term, that the way you enforce international law against them is by military force in response. That is sort of the popular, very like loose popular conception, right? That you have to meet fire with fire, that you know, that's how you kick them out, you get them to stop forcefully. But that's the far end of the international law toolbox, right? We're seeing the full spectrum of the international law toolbox being brought to bear here, which means that every single step, every single decision that's being taken not only has the legal analysis of, is this a step that we can properly take as a matter of law? Is this a step that's available to us under international law? Meaning when we do it, we will not be violating our own obligations to comply with international law. But we also, again, using we, very, the royal we, need to be thinking about what changes in terms of the relationship between the relevant parties might come about. In other words, if this step, this sanction, this chosen response, this sort of measure of compulsion, as to the extent we're trying, would potentially step over some kind of threshold, even if it's lawful, does that then give Russia or some other actor certain legal rights to respond or different maneuver space and so on? And so I think that's a constant analysis that is going on. And it's critically important. We see that with the discussions about, the provision of arms, the provision of fighter jets, putting troops here, putting troops there. Much of that discussion is occurring as a geopolitical matter, but the legal question has to be and is being wrestled with constantly, right? Would this change the status of any given NATO member as from a state that's watching, that is either neutral, if not neutral as a matter of law, certainly not a party to the conflict, or is this going to actually either make this state a party to the conflict, or might it make certain actors or locations in that state lawful targets in response, right? So there's a whole host of considerations there,
Yeah.
and they all have to be addressed. And then you make decisions based on that assessment, right? I mean, ultimately, law is a risk mitigation discipline. That's what it really is. And so that's what we see going on here.
Thank you. So I want to get to you in a second one. I want to ask Lise though first. So what about conversations that might be happening among actors who are non-state actors who are who are also law-abiding, some of the big platforms and that kind of thing, and what kind of conversations might be happening there, which where they're not looking at the law of armed conflict?
Well, I mean, if you single out big platforms, let's take social media platforms, then they, strictly speaking, are not and should not be concerned with them breaching international law, because platforms, they are not bound by public international law. Public international law is a discipline that creates rules for states as between states, with the big exception being international human rights law. But that said, many of the big platforms, Facebook, Twitter, they have committed to honoring international human rights standards in policing content, in regulating content. So I guess the answer to your question is, they are thinking about international law, not because they necessarily have to, but because they have chosen to do so, because of the pressure that they have been under to either engage in more robust action or to not engage in as robust action. I mean, I think they're stuck somewhat between a rock and a hard place. So I feel for those platforms, because they're not being they're not getting regulatory direction from states such that the decision-making process would be easier, so that they would get more guidance from states. So they're left to decide on their own, and what they've chosen to do, at least the big platforms, is to be guided by international human rights law standards.
So thank you. That's great. That's perfect. And Juan, do you want to comment a little bit about this? Sort of turning it upside down in a way. Do you decide what the right thing? What's the best response, and then figure out how it fits into the law? That's normally the way policymakers think. But as you pointed out earlier, many of the players here don't seem to have much concern about these norms and laws.
Yeah, I mean, it's two complete opposites, and sort of to maybe nitpick at an offhand comment Lori made, where about lawyers being involved in the conversation. I think we're entirely disproportional in how involved lawyers are, whereas on the Western side, particularly in the private sector, there are too many lawyers in the room, and then on the other side there are none, and it can feel very it puts particularly Western countries, the United States being the top, in this bizarre position of being incredibly powerful and incredibly useless at the same time. That's not to say that it's the fault of the lawyers. I think at this time we're in a very strange situation where most use of cyber weaponry in the past by the United States, by Western countries, is entirely disavowed. It's covert. Nobody wants to talk about it, which means that we're in a very difficult situation when we want to say, this is what legitimate use of cyber looks like. This is where the lines actually are. This is what we want, how we want to operate as responsible players in the space. And then when you get into the legal side of it, I think it's even harder, as Liz was pointing out, to get any kind of regulatory guidance. You often get entirely contradictory regulatory guidance, as was the case with things like GDPR, which I know GDPR is very popular, particularly in Europe. It's incredibly unpopular in the cyber research space, because what it really did was problematize the storage of data that we need for investigations like this. So you get some very different opinions on this. I don't want to make the role of lawyers seem entirely problematic. I just think that there's so much undefined that it's difficult to ask lawyers to actually help us guide in a direction we're not even sure we want to go.
If I can jump in,
Sure, go
Bruce,
ahead.
I think Juan, you made a point that I forgot to make at the end, which is that while states and organizations and certainly private corporations are heavily lawyered in this space, many of the non-state, whether malicious or not, actors in the cyberspace, the hackers, et cetera, are not. What's interesting, though, is that that's not necessarily different from any other situation, certainly in the context of armed conflict. Don't necessarily see a whole lot of judge advocates or other legal advisors right there providing legal advice to lots of armed groups in the midst of conflict. We see efforts to engage with armed groups, rebel groups, et cetera. And one of the things that we see in the kinetic space that perhaps we don't see in the cyber arena is efforts by many of those groups to actually exploit the law, to create scenarios in which you put the law compliant actor kind of over a barrel, whether by using human shields and things like that. Now, the nature of the cyberspace where I can't see what's going on, you can't take a picture of it for me and put it in the newspaper. So you don't need to have the same exploitation of the law for delegitimization purposes. You can have other ways of essentially exploiting the asymmetry between the actor that doesn't care about complying with the law, perhaps is decidedly interested in violating the law, and the actor that not only wants to but needs to comply for a variety of legitimacy purposes. And I think cyber, with the ability to kind of dance along the different thresholds and stay right below thresholds that would be clear opportunities for a legal response, you're having a similar effect. It's just that you're not having it out in the court of public opinion, right? You're having it for the state and the other actors internally, where they're wrestling with things like, if we respond and we respond in this manner, one, are we stepping out of bounds? Two, are we setting a precedent for others to step out of bounds? And then a host of non-legal things, like if we decide to respond, have we just essentially used up our one chance to use that cyber tool, right? Because you can use your missiles, you can use your fighter jets and your missiles and your bombs over and over. It doesn't matter if someone knows what it does, it still goes boom and destroys things, right? It doesn't work the same way necessarily with your cyber tools.
Yeah.
So different ways for law to create gaps and ambiguities in the cyberspace.
Really, really interesting. Yeah. And I know, Juan, looks like you're ready to say, respond. When you do, also, could you talk a little bit about the problem of attribution that you're seeing, particularly with hacktivists and whatnot? And because it made me think about that when Lori said, those people could be deemed to be therefore combatants. And so, anyway, Lori, go ahead.
Yeah, well, I definitely wanted to agree with Lori. I think she kind of hit the nail on the head on what, at least from our perspective, tends to make the involvement of the lawyers seem problematic. It really isn't the lawyers, but rather just how complex cyberspace is, and how we have a lack of precedent and we have a fear of establishing precedent. And we tend to have to, most of the things we want to do in cyberspace involve the private sector in ways that most things don't, right? There's no such thing as the internet. There are servers owned by Google. There are domains registered by Namecheap. There are VPSs, servers rented by Amazon. So any one step that you want to do, even something as simple as saying, hey, here's a bunch of malicious infrastructure, it's being used to attack Ukraine. We're 100% certain that it's attacker controlled. We're 100% certain that it's affecting these people. Well, taking that down implies what? Are you going to force Microsoft or Amazon or whomever to take that down? Are they willing to? Can you compel them to? Do you ask them to? What happens if they say no? What happens if they take 2 weeks? What happens when you take it down after 2 weeks and in a day they switch over to DigitalOcean, right? Like it's a much more complex space. And I think the legal friction turning into inefficiency tends to turn into futility on the part of law enforcement, government, and so on. And you get disproportionate responses, right? Somebody like NSA or Cyber Command saying, you know what, just let us do whatever we want, wherever we want, and we'll figure it out later. Like, that's compelling, but obviously that isn't necessarily the way we want to go. Bruce, I think you added sort of another layer of ambiguity to this, which is the attribution side. It is not simple at all, for a variety of reasons that I think are woven into the fabric or the physics of cyberspace. For example, it's much easier to reuse things, right? If we build a bomb, as a group, we decide to build a bomb, and we go and we blow up that bomb somewhere, we can't then retrieve that bomb and blow it up somewhere else. I can't, make a copy of that bomb and then hand it to another person who's then going to use it, sort of to stretch the weaponry analogy. So there's so many ways in which attribution becomes incredibly complex. And one great example is the sandworm attack. And, going back to Ukraine, the attacks by sandworm, we were tracking them for years and years and years without having a clear sense of attribution other than to point in the general direction of Russia, saying, look, there's Russian artifacts, there's language in it. Some of the servers might be hosted in Russia. Some of the IPs might be coming from Russia. Now, there's a very big difference between something being Russia-scented and something being part of an official arm of the Russian government that is sanctioned in this way and has been tasked with doing X, Y, and Z. And the difficulties are non-trivial, right? What's the difference between the GRU having a cyber operations arm that undertakes a campaign in Ukraine and the GRU hiring a contractor who decides to do this, or the GRU hiring a contractor, their equivalent of Raytheon, who then hires a company in Taiwan, who then decides to do, there's so many layers of abstraction there. And our best way to bridge them tends to be the intelligence community. And that's where we get into other issues like, the issues of declassification in the United States. If you look at the Mueller report has amazing value in cyber in that it actually pointed at a lot of the groups relevant to the attacks in Ukraine in 2015, 2016, and said, hey, this is GRU Office 77, blah, 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 and these are the people. And that's fantastic. I mean, you go back and you look at that report and you take the last 3 years of investigations and go, wow, we have some sense coming from US government and the bowels of the intelligence community, the depths of it, letting us know that these are the 12 names of people that were probably involved in these attacks. But the gap between the attack and the attribution is 4 or 5 years. And it's based on information, sources, and methods we're never going to get access to. And that isn't even to say, what happens when you're using fake fronts? What happens when the Russians, the GRU themselves, those same offices decide to stand up an anonymous collective from Poland, and that's how they do their dissemination of documents. Or they create a fake group that's meant to be Ukrainians, and that's how they disseminate documents. And all those examples are real from the summer of election hacks from 2016. And it puts us into a very difficult situation where even the best researchers and even the best people in the intelligence community have a disconnect that we find very difficult to bridge before we can even come to you and say, these are the people that did it. Please do something about it.
Well, and you mentioned in our pre-call that what you're seeing right now is new tools and new teams, not the people who were in the Mueller report and not people that we've seen before.
As far as we can tell. I mean, that's the other side of the coordination that seems to have happened in the Russian space. I mean, there's a lot of speculation about how many people in the Russian government knew this was coming and how much preparation could they do. In cyber, I can say that there was a certain amount of preparation insofar as all of the tools that have been used recently in Ukraine seem to be the kind of tools that were developed just for this attack to be burned, right? Everyone's going to scrutinize this. It doesn't connect back to any of the things we've used before. It's brand new to be burned. Obviously, everyone can hypothesize or surmise that it's for the Russians, but the Belarusians are also doing things. So, who exactly are you going to pin this on? And I think the level of coordination that is implied is at no point have we seen these attacks so far trip over another Russian team. So where is Erla, where's the GRU, where are all these groups that we have been tracking for years and years and years who are normally doing espionage in Ukraine and all of a sudden seem to be, shining by their absence, and all we get are these new tools.
Interesting.
So,
Interesting.
they're playing with us in a sense where they've learned how some of these things are done, and they're walking around them.
Well, and as we know, there's a lot of tools that haven't been, and a lot of kinds of attacks that haven't been released yet. I mean, the escalation on the kinetic side is greater, much greater at this point than the possible things that we expected to see. Much more denial of service, takedown of comms and stuff like that. It's really kind of an interesting play. Lise, you in Estonia were among the more recent recipients of Russian cyber attacks. That was some time ago, but what's the sense there, and what other perspectives are you coming up with in the context of this conversation?
Well, I don't work for the Estonian government, and I've actually never directly worked for the government. But what I can say about if you're referring to the 2007 attacks against Estonia, I mean, they were a wake-up call, not for the international community writ large, that cyber now is a national security issue. It was also a wake-up call for the international legal community, that now there is this new method of warfare, or a new method of influencing other states. It's cyber. And it raised the question, well, does international law have anything to say about these kinds of cyber operations? So this really was the trigger for the international community to specifically start looking at how peacetime international law governs those types of cyber incidents. There had been some research done in the early 1990s on how the UN Charter law and how international humanitarian law governs cyber, the areas that Laurie mentioned. But from 2007 onwards, I think the international community's eyes were on the peacetime regime as well. But as I was listening to what Juan was saying, attribution is a big issue in international law as well, and international law provides certain rules for attribution. And so when you're mentioning the GRU, for example, hiring a contractor for the contractor to engage in cyber operations for the GRU, this situation has a very clear answer in international law. We would say that operation, even though factually it was carried out by a contractor, in law, we would attribute that operation to the Russian Federation, and we would say if the operation was in breach of any applicable international law rules, for example, if it was conducted against civilian objects in Ukraine, that would be a violation of humanitarian law. And with regard to the gap measured in years between analyzing a cyber incident or the incident taking place and then coming up with an attribution determination, this is often presented as an obstacle to the victim state taking any kind of meaningful response to that operation. And actually, at least insofar as international law is concerned, that is not true. If we move the analysis out of the Ukraine-Russia context, if there is a malicious cyber operation by one state against another state, and let's say it has some pretty serious consequences, such that we would say that this is an unlawful cyber operation, the victim state is not prohibited from responding if the victim state has, let's say, 80% certainty that it was country X behind the operation. But rather, the legal rule is that if the victim state responds, it does so on its own, at its own risk. In other words, if it gets attribution wrong and it responds against an innocent state, then it has to bears the risk, and it has to face the consequences arising from its unlawful response. But if it gets attribution right, we actually, and the 80% certainty turns out to be correct, then here we don't have an international law problem. So just, be sensitive to the fact that international law necessarily is not just a brick wall that, and international lawyers are not always the ones to tell you, no, you can't do this or that.
Great. Lori, what's been coming up for you in this context of this conversation where it's going right now? We're getting down to close to the end. So.
Yeah, I mean, I think it's really a reminder of the need to integrate law into whether it's operations or analysis or planning or anything. A colleague of mine has a wonderful expression where he tells young lawyers, he says, don't be a dentist, which means don't be the person that someone comes to only when they have a bad problem, right? And the complex nature of everything that we're discussing is just a sort of a heightened reminder of that. And that's really, I mean, what Lisa and so many others involved in the Tallinn Manual and other efforts have been doing for the last 10 plus years is trying to make sure that in the cyber arena, lawyers are not being dentists. Not that dentists aren't great, of course, but most people try to avoid going, right? That can't be the answer in a particularly complex and extraordinarily dynamic area. And it also is a reminder for lawyers that you need to know your client's business. You need to learn it. You need to understand it as best you can. You may never understand it like Juan does in terms of all the cybery stuff, but you have to at least be able to sit and figure out what questions you have to ask and how to either understand the answers or ask more until you figure out how you can provide the relevant legal advice. So I think that would be I think that's an important takeaway here.
Speaking of takeaways, I think one of the things that came out in this conversation early on, which is important, is that, and I think you made this point most clearly, Lori, was that, hey, international law is being violated without doubt in the Ukraine right now by the adversaries and the aggressors. And so, we're having this conversation in the context of a different kind of environment and a different context than often these kinds of conversations have taken place in. This is, certainly on the US side, there's plenty of doctrine around for the use of cyber weapons in theater, right, as a part of the toolbox of weaponry and that is available to modern armies. But again, the applicability of that in situations like the attacks on civilians and other pieces, is not always, followed, even beyond just the inadvertent. And so we've seen stuff come out like that on the kinetic side, in Afghanistan and whatnot recently. It's, the international law status of those things will take a while to look at, I expect. Michael, did you, you've been following the questions, and I know we're running short on time. Anything you want to add here to the conversation?
I will leave it to you maybe for a quick round of fire to the panelists. I think there's much too many questions to address substantively. So let's just have maybe a quick round of fire with the panelists. I know Lori needs to jump off very soon, so I'll leave that to you for the last couple minutes, really.
All right, sir. Thank you. All right. Well, let's go with that. You have your last word. Let's see. Why don't we start with you, Lise?
All right. I mean, unfortunately, we didn't get to discuss many of the cyber operations specifically specifically how international law regulates those and what international law has to say about them. But I think in closing, what I would rather say is that we right now, we're discussing these issues from the comfort of our homes. And let us not forget what is happening right this minute on the ground in Ukraine. Let us not forget that they're not only fighting for the freedom of their own country, but they're also fighting for the freedom of Estonia, for the freedom of Europe. They're fighting for a rules-based international order and its survival. So in conclusion, I would say, Slava Ukraini, honor to Ukraine. I hope the West is not going to sacrifice Ukraine simply because they were too afraid to stand up to the aggressor. Thanks everybody for joining.
Thank you so much, Lise. Juan?
Well, I definitely don't have anything quite as poignant as Liz, but I agree with her point 100%. I will say, particularly for this audience, and hopefully as a better synthesis of kind of the back and forth, particularly between Lori's expertise and my technical field, I think that there's a lot of room for legal experts, both in the United States and in the international law space, to help us better define what the rules of the road should look like in a way that is empowering. There are the amount of power that we have in cyberspace, not just the United States, but also the private sector and most Western nations, is frankly outsized beyond the imagination of what most people understand about how cyberspace works. We could be doing all sorts of amazing things. We have developed capabilities to do amazing things. There are private individuals who can do amazing things. But right now, the ambiguity of the law and just general norms around this is keeping folks in this sort of safe space of saying, you know what, if I don't get involved, I don't get in trouble. And that's the friction there is so much lower than trying to get involved that you would be surprised at how many folks could be helping the situation in Ukraine and aren't. How many folks could be doing amazing things in our government, but feel hamstrung. And I think that the situation needs a drastic change in thinking. And this is one where I don't think the legal side should be reactionary. I think there is an opportunity to lead by saying, you know what, don't overcompensate. These are the avenues you could take to be within certain levels of compliance, but still get to do what you need to do. And, you know, I'd hope that, for example, the Cyber Peace Institute would be an avenue for that. So far, it hasn't been. There have been other attempts to, you know, for the private sector to try to fund initiatives like this. I think it's still completely green fields for a group of brave legal experts to come and kind of help us out of our rut.
Nice. This goes back to your comment about the dentist, Lori. So you get the last word. I know you're on a short, you have a flight to catch, so.
Yeah, so the only thing I would say is right along the same lines as Lise, which is to remind ourselves that all the law we're talking about is about protecting people and protecting communities and societies, and we're watching in real time exactly why this law is so important. So I think we just need to keep that in mind. So thank you so much.
Thank you. Any last words, Michael?
Let me just thank the panelists, Liz, Lori, Juan, for an excellent session. A very pertinent reminder at the end that this is much larger, I think, than any of us. So thank you for participating in this conversation. And thank you to you, Bruce, for moderating so excellently. And thank you to all of the attendees for joining. Stay tuned for more events. And we'll have the recording up for you on the website if you want to look at it again. So stay tuned for that as well. Thank you, everyone, and have a great afternoon or evening, depending where you are.
Thank you.
Thank you.
All the best, everybody. Bye-bye.